Hello, and thank you for joining us. Welcome from me, Michael Scott from Oxford, but currently in the south of France, and from my joint convener, Sanford J. Ungar in Washington, DC, to the 23rd jointly promoted event between the Future of the Humanities Project and the Free Speech Project. The latter is sponsored by Georgetown University, and the former by Georgetown's Humanities Initiative in association with Campion Hall, Oxford, and the Las Casas Institute for Human Dignity, Blackfriars Hall, Oxford. Together, the two projects consider issues concerning human dignity, rights, cultures, histories, traditions, and freedoms in a wide spectrum of educational activity, policy, expression, and aspiration. In a moment, I'll hand over to Sandy, who is director of the Free Speech Project. He will introduce today's distinguished guests and moderate the ensuing discussion before I return to chair the question and answer session. From the start, you can type in questions to the panel by using the Q&A button at the bottom of your screen. Use, please, the Q&A button. Please do not use the chat button. These questions will come to me during the session, and I will try and put them to the panel to consider towards the end. We urge you to ask questions as and when they occur to you, so that there's no kind of bottleneck at the end with lots of questions coming in and we can't order them. So with that, I'll hand over to Sandy. I will disappear, but I'll be listening to the conversation, and I hope, like you, I'll be enjoying it. Over to you, Sandy.
Thank you, Mike, and much appreciation for our long and fruitful collaboration now, coming on 2 years of discussing issues of mutual interest across the Atlantic and around the world. We're particularly pleased today to bring together two distinguished people for this conversation about Julian Assange, his coming espionage trial in the United States, presumably, and its potential impact on journalism. We have only two guests instead of the usual four today, and one is Daniel Ellsberg, who does not need much of an introduction to most of our audience, I'm sure, but I've had the privilege of knowing Dan Ellsberg for more than 50 years now, since he disclosed the Pentagon Papers in 1971, after several years of trying.
We're waiting. Shall I mention something that might not otherwise be mentioned? That Sandy, as a very young journalist at that time, wrote the very first book on the Pentagon Papers issue. The papers began to come out in June 13th, 1971. And I think it was by the end of that year, which seems almost impossible, wasn't, or could it have been the next year? Even the next year would have been early, but he had a book out called The Papers and the Papers, which was a very good book. It's still used, I understand, in journalism classes 50 years later. And here was, I think, almost the youngest of the reporters covering the trial, doing an excellent book of investigative reporting on the background, including the decision-making at the New York Times, of which I was unaware as the source to the New York Times. So he has a very, very long, it's not only a long connection with this case, but he's a scholar of it.
That's fantastic. I didn't know that. I've been working with him for 2 years now, and he's never told me that. So that's something new for me as well. Naomi, I wonder whether we might start though by, could you tell us a little bit about Assange?
Sure. Yeah. So Julian Assange is the founder and publisher of an online media organization called WikiLeaks. And WikiLeaks is remarkable for a number of reasons, but Assange is the guy who invented the idea of an electronic Dropbox where whistleblowers could disclose information over the internet while using the properties of the Tor network and anonymizing technology to hide their identity. So those who had important information to disclose but might get in trouble for doing so could do so electronically in a reasonably secure way. That's the revolutionary technology behind WikiLeaks. And, you know, you wonder how successful Assange expected this to be, but it turned out to be, of course, incredibly successful. And one of the reasons we're still going to be here talking about this today is from 2010 to 2012, WikiLeaks published an extraordinarily important group of disclosures about US US security policy, war and peace, diplomatic relations, these incredibly important topics. This was a collaboration. It wasn't just WikiLeaks doing this. They're in collaboration with the biggest and most prominent media organizations in the world, with the New York Times, with The Guardian, with El País, with Le Monde. And these documents were ultimately sourced from a very important whistleblower called Chelsea Manning, a US military whistleblower. Sandy's back, so I can give him his job back in a second. But this forms the essential background to what we're talking about today.
Thanks, Naomi. I'll hand back over to Sandy now. Okay, Sandy.
Thank you
muted,
very
Sandy.
much. Sorry for the internet woes that I just had. Hopefully they're cured now. I was in internet hell for a few minutes there. Naomi, thank you. Dan, thank you. I assume, Naomi, you've either introduced yourself or someone has introduced you. I don't know whether anyone has said that your organization last year gave Daniel Ellsberg a Lifetime Achievement Award for his work in whistleblowing and making information available to the public. I take it you have introduced
I've introduced Julian Assange, but I've not actually introduced myself. But I should say that so I work for an NGO called Blueprint for Free Speech, and we're interested in free expression and whistleblowing particularly. And it's a real pleasure to be on this panel, and with Dan, whose expertise on this subject is second to none. And
right. Well, the reason we're coming to this subject now is that the case of Julian Assange, some events that I heard you alluding to from 2010, 2011, during the Iraq War, and information made available to WikiLeaks, which was the creation of Julian Assange by Chelsea Manning, a member of the US Army at the time, had profound international significance. And of course, there were many, many documents, videos, other information released. He was charged initially by the Obama administration, which has charged quite a few people under the Espionage Act.
I don't think that's quite true. The Obama administration certainly charged Chelsea Manning, and they prosecuted Chelsea Manning. The charges against Assange, although it was talked about, and it was certainly something that Assange was worried about, and the people around him were worried about, but the charges didn't happen actually until the Trump administration.
Certainly not the Espionage Act charges.
None of them.
Right. Well, thank you for that correction, Naomi. It is a long time ago now that this case has been in the news. And of course, the situation was that the United States requested extradition of Julian Assange from the United Kingdom, where he was held initially and then sought asylum in the Ecuadorian embassy in London, and did not come out for quite a few years because of his concern about being arrested. Recently, the British authorities cleared extradition at the request of the United States for Julian Assange. He appealed and it's been on hold. Can you give us an update of where it stands right now, Naomi?
Sure. So, as you've mentioned, Julian Assange had asylum at the Ecuadorian embassy for many years until April 2019, when he was kicked out of the embassy and arrested. And this is when the US charges against him were unsealed. First of all, charged under the Computer Fraud and Abuse Act, and then about a month later, additional charges under the Espionage Act as well. Extradition is not automatic. there is a legal process around this as well as a political process. And this has been going on in the UK basically since April 2019. Julian Assange sort of won at an initial stage of these proceedings, but then there was an appeal against it, which was upheld. There's now a second round of appeals going on. This is all taking an incredibly long time. We're not going to hear there aren't going to be any more developments about this for the rest of the year, I don't think. So his extradition is not inevitable. There is still process going on. What we can certainly say is nothing is going to be resolved here for a little while. If this second appeal comes to nothing in the UK, then because the legal recourse in the UK had been exhausted, there's still the option of going to the European Court of Human Rights in Strasbourg, which I suspect the people around Julian would be minded to do. If the Strasbourg court decides to hear the case, and other parts of the Council of Europe have been quite outspoken about the threat they think this case poses, then you can add like another year or two while it's heard and considered by the Strasbourg court. So nothing here is going to happen very quickly.
So it's some time perhaps until Julian Assange really comes to trial in the United States, if he does. But Dan, I wanted to ask you why this is viewed by you and many other people as such an important case and such a threatening case should Julian Assange be convicted.
Well, let me first make a little correction here, which is to the point, I believe. It's a point on which I'm somewhat sensitive. Strictly speaking, Julian Assange is not charged with espionage, as the screenshot implies, and has been said a couple of times already. He's charged with a non-espionage charge under what is known as the Espionage Act, because that's what it was intended to cover initially: spying, people who give information secretly to a foreign power, especially an enemy in wartime. And that's all that the act was used for many years, decades after it was passed in the beginning of the First World War, 1917, for the US. And I was the first person actually tried under it as a non-espionage case, which is true of the number of cases we've heard about already here under, especially President Obama, and after him, Trump. Actually, the act is known as 18 USC, US Code 793, paragraphs D and E, and I can put that out trippingly here, though I'm not a lawyer, I'm a defendant, because I was the first person charged under that act for giving information to the American people with the intent to inform them of information that had been wrongfully withheld from them. In this case, a very long history, classified top secret history of our decision-making in Vietnam between 1945 and 1967. So the act, as I say, was not intended to cover non-espionage cases at first, and I was the first experiment under President Nixon for using it in this case. The constitutionality of using this act intended for spies against people who were intending to inform the American public of information has never been tested by the Supreme Court. They haven't accepted a case brought up to them, and only a couple of cases have been brought up to them, which they rejected considering. The use of the act against a source like myself, a former official who had access to this information, is very arguably unconstitutional under our First Amendment, the freedom of the press. Congress shall pass no law abridging freedom of press or freedom of speech. It's blatantly unconstitutional in the eyes of most lawyers when applied to a journalist. And this is the first time it has been applied to a journalist, although in my own case, the journalists, Neil Sheehan and Rick Smith, were actually being addressed by a grand jury, the possibility of prosecuting them at that time, but that was dropped, probably for the same reasons that mine eventually was dismissed, that they had been illegally warrant wiretapped during that period. In any case, this is the first time that an actual indictment is issued. And coming now right to your question, if Julian Assange is prosecuted, I would say even his extradition and his price for his extradition and the indictment are themselves, as they say, cooling free speech or abridging free speech in the way that Congress is not entitled to do in terms of free press, I should say, in particular. If he is prosecuted in this case, as a student of that act, having, as I say, not only been prosecuted under it, but having followed it in other cases for the half century since, I would say he's quite likely or could well be found guilty of violating its plain language, because the plain language stretches very far, not only beyond spying, but really covering even people who read this information without authorization, who hold on to it, or copy it, or give it to a spouse or anyone else. In other words, readers of the New York Times could very well be prosecuted under the plain language of this act, which some lawyers have regarded very poorly drafted, but in any case, which pretty well wipes out freedom of speech, freedom of the press in the whole area of so-called national security, keeping in mind that that's something that's defined by the executive branch pretty much and can cover almost anything in terms of something that could be useful to a foreign power, could be used to the disadvantage of the United States. They don't actually, under that language, have to prove that there was damage to the United States or even help to a foreign power at all, just that it could be. And what front page of the New York Times would not cover that criterion? For example, any page almost of the congressional record, probably not every page, but nearly every page, certainly dealing with anything to do with diplomacy, defense budget, defense procurement, and defense affairs, as is happening in our aid to Ukraine right now, would be covered by that. And to give an example here, Julian was initially, one of the first things that was brought against him was the video taken from an American helicopter of the gunners on the 50 caliber gunners, and I think perhaps rockets, on a helicopter in Iraq, gunning down people who were clearly in civilian clothing, who did not have any arms with them, although one of the gunners thought he saw the arms on one of these people. I think there was, I've forgotten the exact number, perhaps 16 or 17, more than 12 anyway. And gunning them down, apparently civilians. What they thought was a possible rocket was a camera by a Reuters cameraman. And this was put out with the title by Julian, "Collateral Murder." He was criticized actually for that use of the word murder as being too accusative.
That
Actually, it was. So
that was among the in the material that was disclosed through WikiLeaks at that time, and one of the issues at stake in this ongoing argument.
yes, if we were to see, you know, with all the discussion of war crimes, and I'm sure a great deal of it, if not all of it or most of it, justified in condemning what is going on in Ukraine now under the aggressive invasion by Russia. If we were to see that from the camera of a Russian helicopter at this time, I don't think anyone in the world probably would have, certainly in America, would have trouble recognizing that as the commission of murder, of a war crime. Not all killing, as I know from my having been a training officer for a Marine battalion in the 50s, training briefly on the question of war crimes. Not all killing in war is murder, evidently, especially in self-defense of a nation. But a lot of killing in war is murder. And what we saw in that video was clearly not only the killing of the people, including the two Reuters columnists, hunting them down as they tried to hide behind trucks, but the gunning of a car that was coming to help the wounded, in which 2 children were sitting, one of them at least wounded. And the men, unfortunately, being recorded as laughing at this hunt on the ground. The point being that that was murder, and it was something that we don't see in that coverage of any wars to that extent very much, and was very much a matter of bringing home to the American public what was being done in their name in Iraq. So, and there was a lot of other information too about torture, people that we were handing over in Iraq to Iraqi troops that we knew intended to torture them and did torture them, are turning them over without investigating what was going to happen, or the mere failure to investigate this was criminal by international law and domestic law. And that was under President Obama's term, as a matter of fact, which may account for why it was regarded as so sensitive and why the government went after them. The question then is whether, now, interestingly, this video had not been marked as classified, but Chelsea Manning, then Bradley Manning, intelligence in Iraq, came across it, recognized it in various ways, realized that it was being withheld even from Reuters, who were asking about what had happened to their own journalists, and being refused any of that. So putting it out then, I say, was definitely in the interest of the American public to understand what acts were, as some of the participants on the ground described later, everyday occurrences in this war. So to have that as, incidentally, no one was prosecuted for this act in
For the attack on the,
not the person. In other words, it's kind of typical in the use of the 18 USC 793 to apply it to people who expose criminality in the government and information that's being withheld from the public precisely because it is incriminating, or shows deceits or lies of various kinds. And it turned out to be typical in these, that it's the person who reveals this who is subject to prosecution under this very arguably unconstitutional law. For example, our torture program, which was partly revealed by the Manning revelations through Assange, has not led to any prosecutions of Americans involved in this program of torture, which is clearly criminal under, as I've said, international law, our Constitution, and domestic law. Could hardly be more criminal in legal terms. The only person prosecuted in connection with that is John Kiriakou, who revealed the practice of waterboarding and the fact that it was torture. And he also revealed the name of one person who was involved in the torture program. That person was not prosecuted, nor was anyone else, only John Kiriakou. And that's been typical of these prosecutions, which is to say that news coverage of information of practices in the government that need to be disclosed and held accountable is now, to the extent of his indictment, of Assange's indictment, now known to journalists to be subject to prosecution if they're foreigners, to extradition anywhere in the world. If they're prosecuted, very possible convicted on appeal on constitutional grounds, I would say definitely should be overturned, which could be years after this thing had started. Of course, with the current Supreme Court, one can't be sure that they would get that result. In my day, when I was prosecuted for this, there was a very good chance that the act would be held unconstitutional, even applied to a source like myself, a former official who had signed non-disclosure agreements of this. Now that would be much less likely to be overturned if I were to do it today, as I did do about a year ago, and as others have continued to do. I think that we would be reduced to news from journalists who were willing to go to jail to give us that information. And such journalists do exist, absolutely. In
Dan,
fact,
if I
would
may-
guess that you were one of them, Sandy, but and Neil Sheehan and Hedrick Smith and Cy Hirsch, a number of others would be willing to risk their liberty to get information out, but most would not. That's not the way humanity
So Dan,
goes.
I'd like to interrupt you there for a moment. So one of the issues that seems to me at the heart of this case and the ongoing controversy is just who was Julian Assange? What role did he perform? Was he like a journalist? Was he like a publisher? Was he like a reporter, or does he have some other? You were prosecuted as a source, and in the terms we would use, say, for leaking information, you were prosecuted. But Julian Assange seems to be under prosecution for having received information from a member of the military and then made it public. But there's been a remarkable lack, it seems to me, of solidarity with Assange on the part of working journalists. They don't seem to, many at least, don't necessarily accept him as their equivalent. Dan and Naomi too, what would you say about that? Why has there not been more solidarity with Assange on the part of the journalism world?
I think, Sandy, actually, I would turn to you as a journalist. I'm not a journalist, as I say, I'm a source, but the attitude of journalists, I think, has been very derelict on this. There is, of course, a question raised about the nature of journalism in the digital era, and that's what he represents. So as the editor of the New York Times, who had used this information, and I think, if I'm not mistaken, I got a Pulitzer Prize at the Washington Post for it. I'm not certain of that. But in any case, used it to great effect. Said, I'm not sure, he's not a journalist in any way that I recognize. I think part of that has been a reluctance to acknowledge that these journalists are themselves under the gun. By the way, he's not a reporter. He's not an investigative
No, he's
reporter.
not a
He's not a
reporter.
journalist. He's in the role of a publisher, even as an editor. I think he regards himself as a publisher, and most people do recognize him in that fashion. He's gotten a number of journalism awards as a journalist in this role, by the way, over the years. So the fact that he's publishing information and distributing it in the interest of the public, true information, is regarded by many people as defining journalism. He was doing that as a full-time job. Obviously, there's gray areas here where bloggers and people who are very intermittent, these cases haven't been tested yet. As I understand it, neither the Supreme Court nor the law in general, in the most general sense, has really done much to define who is a journalist under the First Amendment. But in terms of providing information, he is certainly in the role of that, in the finest traditions, really, of our journalism.
Naomi.
Sure. So I think it is a very important question that you raise. There are certainly investigative journalists who are very well aware that this case, these indictments, this prospective trial threatens what they do at a fundamental level. And when you look at sort of the civil society organizations which either represent journalists or are concerned with free speech, there's almost unanimity on that front that this is a threat to journalism. There is, I think it is true that in certain ways, and this applies to the UK as well, in terms of sort of the mainstream of journalists, in terms of certain, editorial boards of certain mainstream publications, there's not been a great deal of solidarity. This is partly personal reasons, it's personality reasons, it's probably partly, as Dan says, the understanding that they would also be under threat and not wanting to draw attention to it too much. But I think that whether one wants to recognize Julian as a journalist or not, and it's pretty clear to me that he is, and he certainly, a member of the Australian, Union for Journalists, and has won journalism awards and all the rest of it. The charges that he faces, or the indictments that he faces in the United States, does target from many different directions the fundamental things journalists do. The overwhelming, sort of the underlying theory of the indictments is that a journalist is involved in a criminal conspiracy with their source. So the charges, the indictments sort of attack that relationship from a number of different directions. So he's charged with being in a conspiracy with Chelsea Manning. His receiving information from Chelsea Manning is charged. His talking to Chelsea Manning about what information there might be is charged. His publishing the information is charged. The fact that some of that information was acquired electronically over a computer network is charged separately. It takes all of these totally normal aspects of the journalist-source relationship and charges them from as many different directions as possible.
And
It's
of course,
basically what's going on. Yeah.
Chelsea Manning was charged with a crime, was court-martialed, military trial, convicted, and eventually pardoned by President Obama just before he left office, if I'm not mistaken.
Pardon me, not pardoned, but there was clemency given. There was not a
Clemency
pardon.
given,
Actually.
okay, thank
Yeah,
you.
so instead of 35 years, I think it was she was sentenced to,
30,
which is, she ended up serving 7 years.
But he nonetheless served 7 years.
Mm.
Seven and
And-
a half. 7.5 years. A good deal of it in solitary confinement.
Right.
No. But,
And so, what actually, Naomi, to the next step, I think, is just to clarify a little bit, what is or was WikiLeaks, and what role does it play? Because it, as Dan said, many people now regard Julian Assange as a publisher. If he was a publisher of something, he was publisher of WikiLeaks,
Yeah.
which was not how most people got this information. They got it through the journalism sources to whom WikiLeaks passed it along.
Sure, and you're right. It's worth thinking about what this is, because it has changed the way that journalism is done, particularly journalism around large document sets. So WikiLeaks is a website, if you like. It's an online media organization. It provides a way for sources to provide information electronically in an anonymous or at least deniable fashion. It publishes some information. It doesn't dump things indiscriminately. There's some editorial process there. And latterly, when it was looking at the Manning disclosures, it also coordinated very large, well, in the case of the State Department cables, like extremely large collaborations between a large number of media organizations, all working on the same material, doing their own editorial, making their own editorial decisions about the material, and coordinating that with, common embargoes and that sort of thing, which is now actually regularly the way that large document sets, journalism around large document sets is published. If you look at what the International Consortium of Investigative Journalists, bit of a mouthful, has organizes like regularly these kind of collaborations are normally around large document sets about financial matters, and there's been a whole bunch of these disclosures, the Paradise Papers and the Panama Papers and LuxLeaks, and there's been a whole bunch of them, and there are other organizations doing similar things. So WikiLeaks really pioneered this contemporary way of doing journalism. This isn't all journalism, but it's an important subset of
So it was a sort of intermediary in this process.
It's an intermediary, also doing a lot of digital work, organizing information, and also doing some editorial work as well. I think this is often characterized as dumping information on the internet, which is not accurate.
Certainly, by the way, I
way.
think that
Sure.
Julian WikiLeaks regarded itself not just as a kind of source passing this on, but as a working with and working partnership with the various papers which had dealt with Iraq and Afghanistan. For example, the Times, the Washington Post, the I don't know if the Post actually got in, let me take that back, but Le Monde, El País in Spain, a number of others, so that their attitude was of working with these papers. And something that may come up later, Sandy, the question of redaction or of curating these papers. As it came out during the extradition trial court proceeding, more than had been known before. Actually, the WikiLeaks end of it, Julian Assange took more time than some of these other papers wanted to redact the names of people who might be implicated in a way they didn't want. A great deal of effort was put into that. In some cases, more than the newspapers wanted to spend time on. Oops, sorry.
I'm sorry, I had an internet outage again there for a moment. This never happened before to such an extent in this series of programs. So I didn't hear everything that, was unable to hear everything that Dan just said. I wonder, I would like to ask both Naomi and Dan for their explanation, if they can, why this pursuit of Julian Assange is so dogged. Why? I mean, it's been quite a long time. One might have thought in other kinds of cases, there might have been some reduced charges or some plea bargaining of some sort, or although he may not choose to admit he's done anything wrong or in any way criminal. But why is this case so persistent, and why has it been pursued with such aggressive persistence over time?
Remember, one point here, Sandy, if I may, is that the Obama administration, having, and this came out under the Obama administration in 2010, initially chose, after long consideration, not to indict Julian Assange. Not because there was no desire to do so. On the contrary, the Secretary of State, Hillary Clinton, who was understandably very embarrassed by a lot of what came out, and concerned undoubtedly also, but personally embarrassed, at one point raised the question, why don't we just drone him? And although it was assassinating him by drone, and although when that came out, she said, well, I was joking, other people who heard it did not have the impression she was joking.
Some joke.
It's quite a joke. As we know, President Obama himself authorized the assassination by drone of an American citizen, Anwar al-Awlaki, without any proceedings of even indictment, let alone hearings or prosecution or anything else. Assassinated by drone, as was his 16-year-old son weeks later, in a context we still don't know. So the notion of droning him was not just a hypothetical possibility. Meetings were held on such assassinations every week in the White House. And President Obama actually said at one point, oddly, that he, to his surprise, rather had become something like a rather good killer. It was almost as bold as that, not really reassuring for a president of the United States. But for example, I think that Ed Snowden later was in genuine danger when he was, before he was identified really, as he thought. Certainly I thought that. I was subject to having a dozen people brought up from Miami on May 3rd, 1972, with orders to incapacitate me totally, Daniel Ellsberg, totally. And those orders came from the Oval Office, Richard Nixon. So I don't take such threats lightly.
You're both correct, of course, to say that Assange was not formally indicted while the Obama administration was still
no,
in
it was
office.
rejected. It was considered. It wasn't just
Right.
in process. They had decided not to indict him for the constitutional reasons that I've mentioned. Of course, the way they put it, I think, was people would object The New York Times would object, others would object. Yes, that's true. They would have objected because it was blatantly unconstitutional. And Obama recognized that. Trump was not as bothered by that.
Right. In a few moments, we're going to go to the Q&A with Mike Scott. So I want to encourage our audience to submit their questions in the Q&A button at the bottom of their screen as soon as they can. One thing that is nonetheless closely related to this whole process is that during the Obama administration, the president, and I think particularly the Attorney General at the time, Eric Holder, had decided to use the Espionage Act in the manner that you have suggested, Dan, to discourage leaks, to pursue people who leaked information. And I believe it's correct to say that the Obama administration went after more people in this way than all other administrations combined in American history, which is at odds with the image of the administration, and indeed in the end with some of the clemency granted by the president before he left office. Again, it's been some time now, but how do we understand this attempt to prevent information from getting out, even having declared itself to be an open administration?
Well, it was clearly not acting in accord with the promises he had made earlier to have an open administration. Undoubtedly, as I said, they were used against sources like me. What is the role of sources in a journalistic process? I don't think, let me say, having been at this for 50 years, I don't have the impression that sources like me are seen by journalists as somehow, obviously not as journalists, but as somehow part of the journalistic process. In fact, it's worse. I had a feeling that increasingly, as I saw other cases as well as my own, that a lot of journalists saw their sources the way policemen regard their personal snitches, people, criminals that they have a relationship with and they protect to some extent because it suits the policeman's career to have cases to pursue. And that the journalists really have accepted the idea without question that these people are committing a crime, after all, if it involves classified information.
Dan, I'd have to disagree with you about that. I think that as a reporter, I protected many sources.
Protecting them, yes, but then
and I certainly didn't
do that to their
regard
informants too.
Well, police do protect informants. That's right. But I don't think that most journalists, at least in the mainstream media, at least of a certain generation and tradition, regarded their sources as committing crimes or as people that they did not admire in some way. Yes, some journalists took advantage of their sources, no question about it. And that's understandable, I would argue. But I think that I don't think they saw them as criminals or as wrongdoers for the most part.
Well, I take your testimony on that as evidence on the, I take it in, Sandy, I haven't asked too many journalists this, and what you say is interesting to me, and I'll take it. I will say that I have had personal experience that suggested otherwise, not from you, Sandy, but from others, that it's taken for granted, I think. For example, Sandy, let me ask you this. You covered my trial from beginning to end, as I announced, by the way, when you were not available, mentioned your wonderful book, The Papers in the Papers, the first, I suppose, the first book on a whistleblower, if I'm not mistaken, on a case like this, because there hadn't been a case like this that had never been prosecuted before. So you came out with the first book on that, and really one of the very most worthy accounts, very factual and very good. Let me ask you, of the reporters that you were sitting with in that courtroom with me for a period of almost 2 years, how many of them thought that I had not violated any law?
Well, that's a very interesting question, Dan. I think if we were to go into a deep recollection about your trial and what happened, then I do think that some of the press corps there underestimated the personal risk you had taken by releasing the Pentagon Papers, by making them available. I think that it was seen more as a kind of a moment in political time. And many people only understood later the personal risk you had put yourself at in disclosing the documents.
But I'm asking slightly.
I know what you're
different question,
asking.
Sandy. I know that a lot of them, I was told at the time, thought, oh, he'll never be found guilty. You know, that I would get, in effect, clemency on the part of the jurors because I put out information that was clearly worth putting out and that it was obviously patriotic and so forth. But the question was that I put to you was, how many of them understood as an amicus brief lawyer was put in by the leading constitutional scholar on a question of law of information, Melville Nimmer, who put in a brief later published in a law review that under constitutional interpretations of that time and prior precedent, Daniel Ellsberg had not violated any of the charges that he was charged with, and that if so convicted, that law would be unconstitutional. Now, I don't think many of the reporters covering that, I could even ask you, Sandy, even imagined that possibility that I had not actually violated any law, as Melville Nimmer said.
I did not think you had violated the law.
Really? Interesting.
Personally, I think most of the other reporters there took that same position, that you had not violated the law, and saw this much more as a political trial.
Well, remember,
That's what
almost
was
a couple dozen people have been convicted on the same charges for doing the same thing that I
I
did.
understand, but but the
yeah.
government didn't mess with them the way they messed with you and spoil their own case in those
As they
situations.
have done with Julian Assange. I'm not arguing with you here. I'm just, carrying
No,
this
I
further,
understand.
Sandy.
I
As they
think
have
it's-
done with Julian Assange, without spoiling their case so far. Obviously, it would seem his case should be dropped on the revelation in the Spanish criminal court that a surveillance outfit, supposedly providing security for the Ecuadorian embassy in London, had actually been deliberately surveilling his every conversation with his lawyers, his doctors, and his visitors like me, and providing that information through an intermediary to the CIA. Now, those are pretty much what, and moreover, they had discussed kidnapping him from this and possibly poisoning him. Now, as I mentioned just a moment earlier, there was discussion in the White House, in the Oval Office, of sending people to incapacitate Daniel Ellsberg totally, which, as the prosecutor thought, meant totally killing me. That was one of the factors that led to the dismissal of charges in my case.
Yes,
And it has not done so in the case of Julian Assange.
there
which
was
is,
other
very striking.
absurd. There were other absurd things in your case, Dan, like John Ehrlichman, a close aide to Richard Nixon, sitting down on a park bench in Santa Monica, California, with the judge in your case to offer him the job of FBI director if the case went well for the government.
But
which is a
remember, he
pretty-
threw out our motion to have a mistrial on that grounds and said that
Right.
he had not been influenced. But the things that he did throw it out included the warrantless wiretapping and the fact that they could not find the records of it because the records were being hidden in the White House. They had been stolen from J. Edgar Hoover's private
Right.
files, lest he blackmail the White House with this criminal
Right.
activity. So same thing here. He'd been clearly illegally surveilled during this period. And that has not been yet figured even in his extradition hearing so far. The judge didn't accept it as a grounds for refusing extradition, let alone prosecution.
Dan, I have to interrupt you right at the moment, and I know Naomi has something to say, but we need to go to Mike Scott to deal with the questions that have come in from our audience. Mike, why don't we go to you now, and Naomi will get her points in along the way.
Okay. Let me start with one because it's coming in from Frank Vogel. The US argued in the extradition proceedings in the UK that Assange exposed names of US intelligence sources and so placed their lives at grave risk. If this is accurate, then does this cross a line when it comes to what journalists should do?
Naomi, were you going to deal with that? I can if you want, but I've been
Naomi,
speaking a lot.
do you
So
want to-
Naomi, why don't you?
Naomi?
So yeah,
Naomi?
so if hello, yes. So
Yeah.
in the counts on the indictment which talk about publication, if you like, this is the fig leaf, the rhetorical fig leaf that is being used so that the prosecutors can argue that this is just about prosecuting this person. This wouldn't threaten quote unquote responsible newspapers like the New York Times. This doesn't, if you actually look into the detail of it and the wording, this doesn't really map out. There's also, I mean, and the sort of factual argument isn't really accurate either. In fact, you know, there's been a notable lack of ability to demonstrate any damage that was caused by any of these publications, and this was the case at Chelsea Manning's trial. It's been the case in the extradition proceedings. I'm sure that if there were any dramatic story to be told here, we would certainly have heard it.
It's very difficult, of course, to prove the direct impact of journalistic disclosures of this sort.
Well, it's not so difficult if people discover that somebody named, if anyone was named in this information, turns up dead. There would be
Right.
some ambiguity as to what the connection was. But I was concerned at the time when these first came out that there would be the cover of Time magazine with a headless person on it and identified as someone who had been named in these sources. As I say, a great deal of redaction did go on, and Assange actually did offer more to the State Department and others to take out. Nevertheless, I would say that didn't eliminate any risk. But the point remains, it's been now 12 years since those documents first came out, and they were never able to produce the name of one person who they could identify as having suffered harm as a result, not only the source, but any other person. So apparently the risk, which I did worry about at the time, I will say, was much less than I had supposed.
Could we go to Sienna Mondal, who asks, do you think that because Assange released raw data, that gives the state more reason to prosecute him compared to when these leaks go through the journalistic process, like with the release of the Pentagon Papers?
Well, okay, you
Dan?
mentioned the Pentagon Papers. I actually, a lot of people made a distinction that I had withheld, which is true, that I had withheld 4 volumes of the 47 volumes of this 7,000-page study. And I withheld the volumes dealing with negotiation because I didn't want to interfere with negotiations. I wanted to interfere with a war, an ongoing war. And so I was held up as a better example of a source, in this case, from either Chelsea Manning or Julian Assange. Actually, that's extremely misleading. I identify with their work entirely. When it came out that Chelsea Manning, then Bradley Manning, was the source of these documents, it was mentioned that she was in a SCIF, a sensitive compartmented information facility, a special facility for handling information higher than top secret, communications intelligence, intelligence of various kinds, reconnaissance satellites, and even covert agents, all of which is higher than top secret. It was immediately apparent to me that since she had put out only information from a quite different a channel that dealt only with secret or less, not top secret not above top secret, only secret or less, much of it unclassified, that she was withholding most of what she was dealing with altogether. And for this very same reason that I had, that these were a higher degree, a higher proportion of actually sensitive material occurring in those. And that was actually when President Assange was asked at one point, didn't Chelsea Manning do exactly the same thing as Daniel Ellsberg? And his answer was, Ellsberg's material was classified in a different way. Actually, yes, mine was top secret, hers was secret and below. So in fact, what I saw was that a great deal of discrimination had gone on here. The same is true, by the way, of Edward Snowden. Most of what he put out, rightly so, showing criminality by the National Security Agency in illegal surveillance, was higher than top secret. And it was sensitive information, as they call it, communications intelligence. Nevertheless, he withheld an enormous amount that he knew that he thought the public did not need to know. So in all these cases, I identify with Snowden, with Chelsea Manning, with many others, Tom Drake, Reality Winner, who put out this information, because in all cases, more than I do with Assange, whose role is as a facilitator of whistleblowing, not as a whistleblower himself, but these other people all had access to this information because they had given the benefit of the doubt, as I did, to the people who were doing the decisions and doing the classification, and assuming that they really had, above all, the interests of national security at heart. And when I discovered that most of, as they did, that a lot of it was information that simply would have embarrassed them, that the public should know, they had gone through this same arc of evolution in their thinking that I did. And so I do identify with them. And I find in every case, they have been as discriminating as I was.
Thanks for that, Daniel. Naomi, the same kind of question, but are there any examples within the UK that are comparable to the ones that Daniel is talking about? And secondly, are there any examples of British politicians who are actually taking the side of Assange?
There are some MPs who have spoken in favour on this case. There's sort of a group on the Labour left, if you like, and then there's a few Conservatives, David Davis, who's sort of a grandee in the Conservative Party, and some SNP MPs. There is also a contingent of parliamentarians in the UK who have long-standing concerns about the extradition arrangements between the UK and the US, which is a debate which I think, which has been going on for a long time. In terms of the situation for sources and publishers in the UK, of course, as many of the people attending this will know, the UK doesn't have the benefit of a constitutional guarantee of free speech. And so we'll have what the Espionage Act in the US is sort of turning into, which is an Official Secrets Act. Now, I guess so there have certainly been cases where sources, whistleblowers, have been prosecuted in the UK under the Official Secrets Act. Prosecutors don't have as much power in the UK, so some of these prosecutions have been thwarted by either the government not offering evidence or a jury deciding to find someone not guilty. That happened in a very famous case in the 80s. But actually, it's not been remarked on very much, but the Assange extradition case is actually stands to worsen the situation for journalists in the UK as well, I think. The way that extradition works, I'm going to try to not go into too much detail on this unless people really want it, is that you have to show that what somebody is being charged with in the US would also be a crime in the UK. And the logic used to justify that in the extradition proceedings is that Assange could equally be prosecuted under the Official Secrets Act, but the bits of the Official Secrets Act that talk about public disclosure of information and journalists, not the 1989 Official Secrets Act, but the 1911 Official Secrets Act, which is precisely the parts of the Official Secrets Act which are used for actual espionage, for, you know, spying, nation state spying. So this has always been ambiguous in the UK about whether journalists can be charged under these parts of the Official Secrets Act, which obviously carry much heavier penalties and are, you know, are more serious altogether. But the logic used in the Assange extradition is suggesting that yes, the government is asserting that they can do this and actually propose changes to these older parts. The 1911 Official Secrets Act is pointing in that direction. In the UK, there's been attempts to do this before. There was a case called the ABC trial in, I think it was 78, where a sort of very esteemed national security journalist in the UK, a guy called Duncan Campbell, who's done a lot of original reporting on surveillance in the UK and what GCHQ is up to. Prosecutors in the UK tried to charge him and his colleague and one of his sources under the espionage part of the Official Secrets Act, but that trial collapsed because there was jury tampering and all kinds of nonsense that went on. But yeah, I don't think it's really been noted particularly, but I think it is a factor to bear in mind that, you know, the Assange case has global significance. Its implications for journalists in the United States are incredibly important, but it's going to make things worse, or it may already have made things worse in the UK as well, and facilitated changes in the law which are going to expose journalists to more severe penalties than is theoretically possible at the moment.
Thanks, Naomi. As a Brit, I'm really pleased that it's as recent as 1911 that we're going back. You know. Yeah, we could have. I would have expected we might have gone back to James I and the trial of Henry Garnet, but we better not get into that. Let's go on to Jacob Sowers. Do you believe that public opinion affects the effectiveness of leaks, particularly in the case of Julian Assange? For example, the political tide was against the actions of the US government during Vietnam War, during the disclosure of the Pentagon Papers. However, many Americans are indifferent about the events of the Iraq War and its details. Do you believe this hurts the credibility and effectiveness of leakers like Assange? Daniel.
I'm sorry, that what affects them? I didn't quite get that. What affects the credibility? That
he says the political tide was against the actions of the US government during the Vietnam War. And so you had the disclosure of when you had the disclosure of the Pentagon Papers. However, many Americans are indifferent to the events of the Iraqi War and its details. Do you believe that indifference to the Iraqi War by the populace, do you believe that hurts the credibility and effectiveness of leakers like Assange?
Unfortunately, the American public, and I think they're not unusual in this, like other national publics, are very sensitive to the loss of life by their own countrymen or women, their nationals. And certainly the fact that there were 58,000 Americans who died in Vietnam played a much greater role in our politics than the fact that millions of Vietnamese died in that. In the case of the Middle East now, I think something like 7,000 or 8,000 Americans have died in all of those wars, Afghanistan, Iraq, elsewhere, involvements in Somalia and drone attacks, very many places, which I think has, and there is no draft, so that the youth of the country have not had to have that hanging over them in their career choices, in their educational choices, and so forth. And I think that has a great deal to do with the fact that they aren't as affected by that. For example, why did Snowden's information gain much more attention than Chelsea Manning's through Assange. And my own, there's no question that it did. And why? Well, I think what Snowden showed, among other things, was that we in America were all being listened to by the National Security Agency, that our privacy was all vulnerable to these operations. Whereas what Chelsea Manning revealed was that Iraqis were being tortured. And all of this, and that would sound like an indictment of Americans, but I don't think they're different from any other nations in this respect. So it is not to our credit as a nation that there has been so little concern in this country as to how many war crimes were committed by Americans in Iraq, as there is naturally now among Russians in Ukraine, or the question of how many people were actually killed as a result of our operations in Iraq, which, by the way, were, and this in no way excuses either of them, as clearly aggression as the Russian invasion into Ukraine right now, which doesn't make either of those okay. But as a matter of fact, there was a clear case of aggression in which there was very little interest in this country at any point, along with the question of the Iraqi casualties. By the way, when you asked earlier, were there examples of Britishers? There's a very one inspiring to me, Catherine Gunn, in the British equivalent of our National Security Agency, their GCHQ, which listens in on conversations around the world. And what particularly impressed me about this Britishers' action was that she acted in a very timely way. I first became aware of lying of war in Vietnam in 1964 when I was in the Pentagon. And it's not ever, I'm ashamed of the fact that 5 years went on before I gave that information to the Senate Foreign Relations Committee, and a couple of years after that to the press. Whereas Catherine Gunn, almost the only case known to me, as soon as she became aware that, as she put it correctly, her country, the British, was asked to take illegal acts to get them into an illegal war, that she acted almost immediately within 24 hours to copy that and to get it at risk of her freedom. And she was indeed indicted and charged as a result of that. And the case was dropped when it came out that the defense was about to call a witness from the Foreign Office, the highest Foreign Service officer dealing with law, Elizabeth Wilkinson, to testify to her belief as a legal officer that the British participation in that war was illegal without a further resolution from the UN. And she had given that opinion earlier. And the question was then, was this information that Catherine Gunn was putting out, was it in the interest of the country to know? And as soon as they understood that that witness was going to testify that it was an illegal war and that the surveillance that our NSC was asking British GCHQ, the counterpart, surveillance on every member of the UN Security Council in order, including their private phones and their office phones, in order to get information on them to manipulate them in supporting the war, which was an aggressive war. Well, the prosecution dropped the case that day, as is shown in quite a good movie. Maybe you'll remember, I'm forgetting the name of the movie. Does somebody remember? Official Secrets, was it? Is that it? That
Correct.
quite a good movie that was done on the Gunn case. So yes, there have been cases like that. Of course, they arise. A difference between the two countries is that the constitutional issues that I've been talking about in the US don't arise in Britain because a war of independence intervened. And as a result of that, we got a First Amendment to the Constitution on freedom of the press and freedom of speech and of religion and of association, which the British, as far as I know, don't have constitutionally to the same extent, at any rate. So I would have to say that Assange or I would almost clearly be guilty of violating the Official Secrets Act, and that would be upheld, I think, at the highest levels in Britain. The question is, I think our First Amendment was an improvement on the British legal system, and that they would be well advised to move in that direction. Both of us are moving in the other direction, the US and Britain. Britain is tightening up its Official Secrets Act, making it broader, I think, and higher sentences and what. I think that's a very deplorable direction. And of course, the US is doing the same, using the Espionage Act as a tight Official Secrets Act. And I'm hoping either that Biden will drop this wrongful prosecution and drop the extradition case, which I have to say I don't expect, because when he was vice president, he called Assange a high-tech terrorist, which I would say is an absurd statement, as well as slanderous. But terrorist for putting out truthful information, not really. But that doesn't make him. That does explain why he has continued a prosecution brought by the Trump administration, rejected by the Obama administration. He continued it and is likely to do so, but he could change it, and I wish he would.
Thank you, Dan, for that. Naomi, would you like to make any last comments?
Oh, so, well, how can I follow that? So I
Sorry.
would say that, so just a few points just to follow it. The first is that Dan is completely right, that the British government is making a deliberate decision at this point to make things worse for national security journalists and whistleblowers. There was although we don't have a constitutional guarantee of free speech, we are still just about signatories to the European Convention of Human Rights, and Article 10 there does grant certain free speech rights. Historically, the UK has not been terribly good at respecting those rights. But there was a report not so long ago from the Law Commission, which is a sort of a non-political group of lawyers who advise the government on technical changes to the law, that said that to be compliant with the European Convention of Human Rights, now the UK should make sure that there is a public interest defence in the Official Secrets Act. So that's the expert view, if you like, and the British government at present is trying to shelve that, and actually that's a bit too inconvenient to think about, so they're going to tighten up another part of the Official Secrets Act. That's a deliberate political decision. Going back again to maybe the last question, is that does the public reception influence the effectiveness of leaks and disclosures? Well, I would say that actually, information getting out to the public is one of the ways in which public opinion is formed. And an informed then political action happens. In fact, I think the disclosure of information is one of the best triggers for political action we have at the moment. And what is of interest in one country differs elsewhere. It may be that the reception of some of the WikiLeaks disclosures in the US may not have been as great as it could have been, for instance. But if you look at the reception that some of the State Department cables had in Tunisia, in the Middle East, in 2010, that was extremely dramatic. Amnesty and others have said, it's one of the contributing factors to the Arab Spring. And what was that? It's so people in Tunisia could read what the US government had been saying about their government, and had to have it confirmed on paper that the opinion in the US was that their government was corrupt. And that was, that sparked off an enormous reaction among people in a way that it's not obviously contrary to American interests. It's just saying what the American government had been saying about their government and the way things were in Tunisia. So I think the Assange prosecution is problematic for many, many reasons. But what we're talking about ultimately here is the right of people to have information about the things that affect them directly. And that is matters of war and peace, but it's also about the state of their government. Because if you if you're not don't have access to that information, it's very difficult for you to acknowledge it and to do something about it. That's what we're talking about. You know, it's not just to be informed to know more, but to be informed so that you can take action on the basis of that information. And that's really sort of the foundations of liberal democratic thought, and this idea, you know, you have information, you can act on the information. And I think we need to be very careful about action, you know, about any actions which limit that.
Okay, thank you. Thank you very much. I'm going to ask Sandy now if he's got a last word or so before I close up. Sandy? Yeah, you're muted, Sandy.
I've had repeated internet interruptions during the course of this program, and I'm awfully sorry for the impact. Naomi, I just agree totally with what you just said. This access to information, the freedom to express oneself, to speak, to publish, are so essential to the preservation of democracy and greatly under threat in this country right now, as I am persuaded by you they are in the UK as well. And that's what my Free Speech Project endeavors to do. Thanks to you both for your time, your quality reflections on this matter. I'm sorry that technical difficulties got in the way of a smoother program.
GCHQ at work.
Well, I don't know who was at work. I fear
International cooperation, of course, with
it was just Comcast, and we have to blame in this case. But thanks to everyone, and to ongoing support that we have from Georgetown University, the Knight Foundation, and many individuals who are committed to trying to defend free speech. And Dan, it's a pleasure to see you still going strong on all these issues. Even if we don't agree on every minute detail, I have profound respect for what you've done, and you did it on behalf of all of us. Back to you,
Looking
Mike.
at you, Sandy, it's hard to imagine that you wrote that book 50 years ago.
Well, can I come in and say also my thanks to Dan and Naomi. It's been a terrific, if not at times sensational discussion, and also to you, Sandy, for your contribution, not just as a moderator, but as part of the panel. It's been a marvelous hour and 15 minutes. I'm sure more than that now. We've gone well over time, but I'm absolutely full of admiration for the three of you for what you do. The next free speech project at the Crossroads, ladies and gentlemen, the International Dialogues event, will, in association with the Future of the Humanities Project, will be on Monday, the 17th of October, and we'll be discussing issues of free speech in national and provincial presses. So I hope you join us for that. We'll have another great panel talking. I'd also like to mention a new series that we're starting, which is on Tuesday, the 11th of October. It's within the kind of literature humanities area, and it's called A Bent But Beautiful World: Literature, Arts and the Environment. And we start that on the Tuesday, the 11th of October, with a joint talk by Professor Catherine Temple from Georgetown University, and also by myself. So, and we'll be talking about literature and the environment at a time now when the environment is so much in our minds. Thanks to colleagues at Georgetown, at Campion Hall. Thanks also to Dr. Nick Austin, the Master of the Hall, and to our administrators, Trudy Preston and Ying Ying there. Also thanks, our thanks, of course, to John McCabe in Georgetown and colleagues who make this make the technology work for us. Thanks to Laura Lees, my publicist, and to Maggie Scott, who helped me so much in our side of setting these things up. I'd like to thank everyone who's asked questions. We weren't able to include every question, but I think we covered the areas of all the questions. If there were anything that we haven't covered, we will try to endeavour to do that through email. So thank you for attending today, for all your support for our various series, and especially to Sandy Ungar, the director of the Free Speech Project at Georgetown, to Naomi, and to if I may say so, the legendary Daniel Ellsberg. It was a delight to hear you, Daniel, and we wish you well. I'm Professor Michael Scott, Fellow and Senior Dean at Blackfriars Hall, Oxford. You can follow me on Twitter at Mike Scott Prof. Until next time, take care, keep safe, goodbye, and thanks. Bye-bye.